Hi folks, you're with us today, Tacitus today at your Pushback channel. Thank you for joining this audio live stream. In this essay, I'd like to talk about one of my pet peeves, which is the administration of law or the theory of law, the practice of law, jurisprudence, as we can sort of generically call it. Now, the standards of jurisprudence have existed for quite some time and took many hundreds of years, hundreds upon hundreds of years to develop to the stage we have today. That quality of jurisprudence, which is the best it's ever been, is being ruthlessly dismantled by the globalists. The rule of law and due legal process just get in the way of implementing the globalist ideology. So if it's useful to them, sure, they'll use it, but if it gets in the way, they'll happily, casually and aggressively dispense with it. And that's where we're at now in the Western world. So I just want to talk about legal tactics. Now, in terms of the rule of law, that is, the law is applied equally to all citizens. If you if you steal the chocolate from the chocolate bar from the grocery store, then whatever punishment is given out to anybody who does it receives the same punishment under the law. The law is applied equally and evenly and without prejudice, and so it should be. Now we've gone through a reversal of that when now in the race politics of our era. So more black people steal chocolate bars than white people, which means more black people are getting prosecuted. So the outcome is different. There are more black people prosecuted, therefore there must be something wrong. Therefore, why don't we just not prosecute black people? Problem solved. That type of mentality, and that's crept into a lot of things. So the different application of the law, depending on Marxist style positioning of victimhood, will determine whether or not the law should be applied to you. So law is applied vigorously to straight white males, for example, but the law is not applied as vigorously, sometimes not at all, to people who are not straight white males. The proverbial black lesbian, for example. So this has created a very perverted sort of functioning of the legal system. And in order to sort of aid and abet this, the universities are brazenly and openly taking in low IQ morons as law students and then passing them out as lawyers. And these people will then later become magistrates and judges and other officials in the legal system, prosecutors, district attorneys, attorneys general, and so on. And some of the attorneys general, I've seen over the last 20 years, I'm going, fuck, how did you ever get to be even a junior lawyer? And anyway, so this is the stage this is the overall, and it's getting worse. This is the overall situation that we're in here, where due legal process is arbitrarily applied based on globalist objectives in effect, but using race, gender politics and sexuality politics to sort of stick out front as the stalking horse. But I just want to talk about the courtroom tactics now, because the globalist DAs, funded by George Soros and that sort of thing, they've come under a lot of fire for not applying the law equally, for not bringing charges against, say, Antifa, or not bringing charges against climate activists or organised street gangs that are, the organised looting rampages and things like that. So what they've started to do is they've started to arrest, the climate activist or the Antifa activist or Antifa street goon who's running around assaulting people, that sort of thing. So they've started to arrest those people and bring charges. But then you'll notice how the success rate with charging these Antifa and climate change people, the success rate of the prosecution is minuscule. And I noticed this recently, and I thought, wow, that's just incredible. I just assumed it was in every case. It was activist judges that were letting them go. But I noticed in one case recently that the judge is obviously not an activist. And still the prosecution failed. So I was thinking, well, what else is going on here? That seems odd. Here's a very clear case of law breaking. They've been arrested. They're brought to the court, and they're somehow the case all falls over. So I just want to talk about how the little tactical things, the activist DAs and their activist globalist flunky buddies, what they're doing to make sure the prosecution does not succeed. So the people who are arresting and prosecuting and taking it to court are doing everything they can to make sure that the prosecution is unsuccessful. Now you go, what? So let me talk a little bit about that. Now let's say tactically, so they're doing this at a tactical level. Let's say that you have to have your court documents filed by Friday the 10th of that month. Well, the prosecutor's office simply doesn't file the documents by Friday the 10th. Instead, they file it by Tuesday the 14th, and so they've missed the filing deadline. Now, in an official sense, given you've missed the filing deadline, you can't then go to the judge and say, well, why don't we just pretend that didn't happen, because your evidence has to be filed by a certain date. So given that you haven't filed it by a certain time, then you can't present that evidence in court. And there are rules that govern this sort of thing. And that's fair enough. Well, why not? So it stops people using delaying tactics or obfuscation tactics against the other side. But it assumes that everyone involved is filled with a sense of public duty. They're filled with goodwill. That they're obligated to follow the rules, and they believe they are. They believe in the law. They believe in it. So they are full supporters and believers, goodwill all around, and so on. But that's not what we have here. We have, in fact, a bunch of activists in judges and all levels that believe that the Western law, evidence, facts, and so on is not legitimate. It's not legitimate. Yet they're working within it and drawing salaries, but they're actually working from inside to destroy it. They believe it's completely illegitimate, and they're working inside to destroy it and to ensure that they achieve a maximum level of dysfunction in the practice and application of the law. So what they'll do is they'll just file the documents late. Now, just in case the attorney on the other side representing the Antifa guys, or the climate change, or whoever it might be, that lawyer is an activist, employed by activists, paid by activists. They're not, they also believe the system's illegitimate. So you've got the prosecutor and the defense attorney, and 50% of the time, at least, the judge, none of whom believe in the rule of law, due legal process, evidence and fact. No, they believe in none of that shit. They believe the whole system has to be torn down. And the three primary practitioners. But just in case the defense lawyer misses it, and because they're all part of the same crowd, the prosecuting attorneys or the prosecutor's office will say, "Hey, guess what? We filed the documents late. You can just say that, hey, there's no evidence against my client. My client must walk free, Your Honor." And so that's exactly what happens. But this wasn't an accident or an oversight or a prearranged. Now, in some cases, and often, by the way, if it's the reverse is the case, then the judge will say, well, look, I'll give the other side another week to file your documents. Now, let's just change this around and say that it's a straight white male who was within 100 miles of Washington, D.C. on January 6th, and the prosecution fails or files late or doesn't file at all, maybe by the time the matter comes to the judge can say, well, that's not a problem, Shaniqua, the prosecuting attorney, that's not a problem, Shaniqua. The courts can, and the judge has this discretion, by the way. The judge says, well, I'll give you another week. I don't know, fortnight, would that do? For 3 weeks? We'll just hold that straight white male in solitary confinement while you get your shit together and file those documents. So you've got another 3 weeks to. Now, in reality, the judge, should, just on the strict observance of things, throw the case out. Hey, you've had months to prepare this. You still can't file your documents. You've got no evidence against this guy. I'm going to let him go. We've already had him in detention for long enough. Mr. Billy Bob Smith, you're free to go. End of story. Boom. And that's it. Now, with a stroke of a pen, a judge can do that. With a stroke of a pen, a judge can put you in prison or let you out. That's how it works. I mean, it's kind of frightening in a way, but so we bestow a lot of responsibility on these judges. So as a society, we have an absolute obligation to make sure these people are not only well qualified, but utterly and completely impartial. But that's not what's happening. So tactically, they'll just file the documents late, or they'll file the wrong evidence. That's another tactic they use. Remember, they'll use this tactic in sham prosecutions. They've got no intention of prosecuting the Antifa guy or the climate change activist. They're going through a pretend exercise. Well, look, we arrested them, we did, but the judge let them go. What can we do? You know, the law's the law. And so they produce that. They come out with that bullshit. But it's just so that they can have their, 50 Antifa activists were arrested, and 50 were let go. But they just get the arrest headline. Everyone says, "Oh well, yeah, okay, it may be a Shaniqua and everything, but she's still arresting the Antifa people." But that's not really right. It's been prearranged that none of these people are going to see 5 minutes inside a jail cell. All their costs, legal costs, will be paid by some charity or NGO. All their legal representation will be covered, and they'll be deliberately, by misuse and abuse of tactical, underhanded behavior, they'll all be let go. So it could be filing documents late, or filing the wrong documents, or not filing all the documents that are needed. And the judge, most of the time, it'll be an activist judge, not every time, but most of the time. So the judge will go, "No, I'm throwing your case out. You've got no evidence." Because again, if you haven't filed the documents, the proper documents, then in a strict observance of the rules, you have no evidence against the other person, so they have to walk free. The other thing they do is they just don't turn up for the hearings. So now, again, this is something I've seen this where I've watched this personally, where the other side, the straight white male who's in the dock, that the other side just doesn't turn up, and I've seen cases where the judge effectively prosecutes the case for the Shaniqua district attorney, coercing the witness into saying, "Yeah, I'm bad. Yeah, I did it. Yeah, oh yeah, I'll pay a fine and I'll do this." And usually they're lower IQ people that are easily bamboozled, or they can't afford their own lawyer. Remember, the Antifa guys are all getting free legal aid, free lawyers. The straight white guy out there, if he can't afford it, that's tough shit for him. No one's going to come to his aid. No one's going to come and help him. Damn straight white male fucking Nazi. So we're looking at a very perverse and landscape that's being aggressively undermined by these various forces. But if the prosecutor doesn't turn up for the white guy, the judge will, in just for every instance, give more time to the prosecution or the people that are out to get the straight white guy. Whereas in reverse, the judge will almost never give extra time. No, haven't got your case ready, but of course they haven't turned up. Well, Mr. Smith. The prosecution hasn't turned up, so in that case, therefore there's no case against you. You're free to go. Thank you, Mr. Smith. End of story. That isn't what happens. But if it's the Antifa guys there, then it does happen, and the judge lets them go. So so they deliberately don't turn up, or they file the wrong documents, or they file late, or something along those lines, but deliberately break the rules, so the judge has an excuse to say, "Oh, you can go free." And again, it's a prearranged, it's a choreographed dance macabre here that they're engaging in. Another thing that I've noticed they do is they'll send an intern, a junior intern. She'll be some little waif of a girl doing first year law, and she's in the first semester of first year law, and she'll say, "Excuse me, Your Honor, I'm representing," and that's it. And that'll be the prosecutor. And she doesn't know what to do. Do you have anything to say, Ms. Jones? And she'll sort of stand there, stunned, rabbit in the headlights, deer in the headlights, unable to say anything. And so the judge just throws the case out. So they deliberately throw the case is really what happens. And there's various means and devices for doing that. The judge has the discretion to give them more time, but doesn't. So these are the sort of things that they're doing. Now, I've mentioned at other times how in activist courts a very low burden of proof. Well, you see this with the Fannie Willis case in Georgia. An exceptionally low burden of proof has been allowed to get through to reach grand jury charges, and an activist judge will be appointed to hear it. We already know that. So a very low burden of proof there. But if you look at the ideological and vague, arbitrary nature of the charges against Trump, then it's going to force Trump into, or his legal team, into meeting a very high burden of proof. We say that you were thinking something at this time. And now trying to prove you didn't do something you didn't do, particularly when we say you were thinking something. Now, no judge worth 1 cent, 1 penny would allow, we say you were thinking something and that's illegal. No judge would allow that in a court. But we're looking at a situation here where that is being allowed. So that automatically creates an unusually high burden of proof on the other side. These tactics are also being used, and used in reverse, a very low burden of proof for the Antifa. You have to prove that this Antifa person was, the twin brother of Joseph Stalin and Mao Zedong and Pol Pot. And if you can't prove that, I'm throwing the case out. So very high. So the burden of proof is again. Now, it was once the case where, I suppose it wasn't a perfect system, but certainly by my observation, it was applied with some rigor. Was the idea that the burden of proof was applied equally. The rules of evidence, that the weight given to one person's evidence was no less or greater than the other, unless it was tested in a court and proven to be false. The information was unfounded, wasn't based in fact, or somebody was committing perjury or whatever. But the at the beginning, before the evidence was tested, all evidence had equal weight, and this is patently not the case today. And the Trump case of January 6th and so on, all these political ideological trials clearly show that the evidence of one side is given great weight, and the evidence of the other side is given much lesser weight, whilst at the same time the one side is given a huge burden of proof to meet, whereas the other side is given a much lower burden, almost entry-level burden of proof to meet. But I just wanted to talk about these tactical things. I think it's important to understand why so many of these cases fail. I've seen cases fail in climate change, against climate change people here, because of incredible sloppiness in the prosecution, sloppiness that I don't believe is accidental, and clearly isn't, given there's now a very established pattern of that sloppiness. When they don't want to prosecute you or send you to prison or fine you, they just do an unbelievably sloppy job of the prosecution process. You've been fantastic today, your pushback channel. Thank you for listening.